thank you all so much for joining us today for our first Human Rights in Practice event of the semester, The Truth About Rendition and Torture and Inquiry in North Carolina. The event today is presented in collaboration with Rights Watch, which is a Duke Human Rights Center at the Franklin Humanities Institute and Forum for Scholars and Public Series. And we also have co-sponsorship from the Center for International and Comparative Law, the Duke Human Rights Center at the Kenan Institute for Ethics, the Human Rights Law Society, and the International Law Society. So thank you all so much to our co-sponsors. I also wanted to take a moment to give a huge thanks to our speakers this afternoon. And I'm amazed that we were actually able to find a time that worked for everyone. So thank you so much for your flexibility and willingness. We have a really incredible lineup of speakers who've been absolutely instrumental in efforts to uncover the truth about rendition and torture in North Carolina. And I'll introduce them briefly in the order in which they will speak today. So first we have Dr. Christina Cowger to my right, who has led the efforts of North Carolina Stop Torture Now, a grassroots coalition with the goal of stopping torture everywhere that's been actively working since 2005 to expose and end North Carolina's role in the U.S. torture program. Next to her, we have Catherine Reed, the Executive Director of the North Carolina Commission on the Inquiry of Torture, NCCIT. Professor Jayne Huckerby, the Director of the International Human Rights Clinic, who was also one of the expert witnesses at the Commission. Professor Jim Coleman, Co-Director of the Wrongful Convictions Clinic, who served as a commissioner on the NCCIT. And Professor Robin Kirk, the Faculty Co-Chair of the Duke Human Rights Center at the Franklin Humanities Institute, who was also a commissioner on the NCCIT. So in just a moment, we'll hear from our speakers, but I did want to start out by providing a little bit of a background to the issue that we're discussing today that might be helpful. So on November 30th and December 1st of last year, the NCCIT, consisting of 11 commissioners, including Coleman and Kirk, as I mentioned, heard testimony from victims, former interrogators, religious leaders, and others on the role that North Carolina played in the CIA's rendition, detention, and interrogation program after 9/11. The commission is truly novel in that it is the first independent state-level inquiry looking into North Carolina's role. So how is it that North Carolina is implicated in the CIA's program? One of the major ways is that a company called Aero Contractors Limited operated 2 aircraft from North Carolina that reportedly conducted more than 80% of the U.S. government's renditions between September 2001 and March 2004. It reportedly transported 34 individuals in CIA custody. This means, as you can see from the tables behind me, that almost 1/3 of the at least 119 individuals known to have been in CIA custody were transported by Aero, this North Carolina-based company. And according to researchers, Aero is confirmed to have transported 49 individuals in the rendition, detention, and interrogation program. Local and state officials in North Carolina are also implicated because they provided 2 of North Carolina's public airports for rendition flights and refused to investigate any allegations into their role. So I'll be asking each of the panelists a couple of questions, and then we'll open it up to your questions and comments. So starting with Christina, as I mentioned in the introduction, you've spearheaded the efforts of North Carolina Stop Torture Now since as far back as 2005. Can you share some of the examples of the efforts that you've been engaged in since 2005 to try to seek accountability for North Carolina?
Sure, and thanks very much for having me. It's a pleasure to be here with you. We are a grassroots network, and so we've used a variety of tactics and tools that were at our disposal, primarily to try to educate North Carolinians about the fact that we have this local connection to the global issue of the U.S. post-9/11 torture program. So that local connection gives us not only an obligation to do something because it's our tax dollars here in our public airports that are facilitating torture, but it also gives us an opportunity. And I think we've always looked at it as an opportunity that other states may not have in the same way, although they may have other connections into the torture program. Making that local to global connection has really figured strongly in what we've tried to do. And for example, very early on in 2005 and then again in 2007, people organized protests at the Johnston County Airport, which involved citizens' petitions to the Johnston County Commissioners, but also implicating aero contractors directly, walked those petitions onto aero contractors' grounds and were arrested for nonviolent trespass, and then were able to use the forum that arrest and, in one case, a trial then subsequently provided to educate people about the crisis of torture that was going on. Plane spotting is another tactic that involves the airport there directly in Johnston County. So actually, we were able to see some aircraft that were listed in European human rights reports as implicated perhaps in the rendition program, landing and taking off. It's a little sleepy airport, but you can get up to the runway and you can use binoculars. So in one case, we organized a plane spotting teach-in where people were taught about tail numbers and taught how to, identify planes on the runway. And we did that in a public place by the airport perimeter where the News and Observer could come and take pictures and do a story. Another way that the airport has provided us with a nice local opportunity is adopting the highway in front of the airport, which allows you to put a sign up on Swift Creek Road, which is the airport address, saying North Carolina Stop Torture Now, adopt a highway. Mm-hmm. Of course, then you also have the obligation of going there 4 times a year and cleaning up the actual trash on the highway. So with opportunity come requirements. Kind of moving from and I should say too that we approached the Johnston County Commissioners and the airport authority that works for them with a proposed policy to prohibit further kidnapping and torture-related flights emanating from their airport. And that policy was drafted by the Duke Amnesty International chapter. And I see Jeff Mock here from Amnesty. So that goes back to 2008, actually. So this has been in the works for a long time. But there are opportunities for human rights activists around the state to participate in drafting proposed policies that would actually shift North Carolina from being a torture-friendly, torture-hosting state to a state that explicitly, in a policy sense, prohibits further involvement in torture. And that's a really, I think, compelling direction for us going forward. The last thing I'll say is we've worked at the state level as well, and 22 state legislators spoke up. So we often say, well, our elected officials at the county, state, and federal level have turned a blind eye and a deaf ear, and that's mostly been true. But there have been state legislators, and some of them are actually still in the General Assembly, who contacted the SBI director, didn't get satisfaction. Then they contacted Attorney General Roy Cooper, got rebuffed by him, and then they introduced a bill to overcome the objection that he specifically raised. He said, we don't have original jurisdiction. We can't independently investigate criminally because we're not invited by the Johnston County District Attorney and we're not invited by the sheriff in Johnston County. So those legislators introduced a bill that would allow him to convene a grand jury for investigative purposes. The bill didn't succeed, but it was the first and only state-level legislation aimed at challenging and unmasking how the United States was conducting its torture program. So those are just some examples of kind of tactically different things that have been done to try to create awareness, create visibility, and put pressure on policymakers at different levels.
And Christina, you've touched on this a little bit, but can you also share some of the most significant challenges and obstacles you've faced, and also what has driven you to continue persevering despite some of those real obstacles that have come up?
Sure, and thinking about that, I would have to say that one of the biggest obstacles that we have faced is the indifference of starting at the Obama administration and then kind of working its way down to coming to grips with the U.S. torture record. I mean, it's one thing, and it's horrible, that the Bush administration allowed and, in fact, oversaw the design and execution of a deliberate, systematic torture program involving techniques like water torture, like rectal feeding, that these techniques were systematically administered by one administration is terrible. It's equally terrible and in some ways more insidious that the Obama administration chose deliberately to look the other way and to only look forward and not backwards, because what that communicates then to the American people, to liberals and moderates and supporters of the Democrats, is this must not be an offense that can be called to task. This must be something that we occasionally have to do, because even the Democrats agree that we can't hold anyone to account. And so I think that is one of the main things that's contributed to up to half of the American people now answering poll questions by saying, yes, our government must sometimes torture its enemies. And in the case of North Carolina efforts to hold aero contractors accountable, what that has meant is that Beverly Perdue and Roy Cooper, of course, Governor McCrory, but now Governor Cooper as well, have continued this attitude of see no evil, hear no evil, do nothing about this problem, don't even acknowledge that it exists. That message is coming from on high, and it is firmly registered by state and local officials.
Thank you. And finally, having been so centrally involved in efforts seeking accountability for so long, what do you hope will come out of the work of the commission?
Well, I think a lot of things can come out of this commission, and I'm looking forward to what other people have to say on that score as well. But one of the things that I think is very possible and is extremely meaningful to the hundreds of survivors of either direct CIA torture or torture by foreign proxy countries for the CIA is that there be a formal body in the United States that acknowledges and recognizes the violations that they've experienced, because so far none of them have received any further acknowledgement than a mention in the Senate torture report, which is something, but a lot more in the way of acknowledgement and apology is needed for robbing those people of years of their lives and for permanently damaging their mental and physical health. So I think that the Commission is very capable of communicating that in a way that will be strongly received in many parts of the world, including here, but not only here.
Moving on to Catherine. So over the 2 days of the public hearings, witnesses testified and provided incredibly rich and detailed information. The witnesses had very varied backgrounds, ranging from victims and relatives of victims, such as Mohammed Slahi. And we also heard from, for example, the former UN Special Rapporteur on Torture, lawyers and human rights advocates, medical professionals, former military interrogators, religious officials. Can you tell us a little bit about the process in terms of the selection of witnesses and the story that you hoped would emerge from this sort of collective narrative?
Sure, well, thanks, and just to echo Christina's thanks for having us today. It's great to be here. So at the start of the commission, the commissioners had decided upon a scope of what they'd like to cover over the course of the commission's life. And so as part of the process of exploring witnesses, we looked at that scope really to see how can we find individuals that are able to elucidate on different parts of the scope. And worked with members of the NCCIT Advisory Board and human rights organizations and our own knowledge of where individuals who would be willing and able to speak on this. And so we generated a list that was, of course, much longer than 2 days of hearings would allow. But as Christina spoke about, part of the goal of the Commission is public education, particularly as we now sit out 10 plus years after this program was going on. So we thought about who would make most public impact at a hearing, and who might be better or just as well served by having their testimony be written. So we thought about that, who was going to convince a North Carolina audience. And so, as you mentioned, we had members of the military. North Carolina is obviously a heavily military state, making the case as well about why torture doesn't help our national security. We wanted to have more survivors. As you mentioned, we were honoured to be able to have one survivor testify over Skype and then the wife of another survivor. Unfortunately, those survivors who are still in Guantanamo are prevented from speaking. And then there's many others who just don't want to relive the trauma of what happened, and they don't see necessarily, if they've told their story, what is the tangible benefit from me for continuing to re-traumatize myself by telling it again. In terms of the story that we wanted to tell, the first was really making the clear connection to North Carolina, because people always ask about the commission. Well, why North Carolina? What North Carolina? What's the involvement there? So, we kicked off the hearing with a strong presentation from Sam Raphael of the Rendition Project, who've done the most comprehensive research using public data about making this explicit connection between this company, Aero Contractors, and North Carolina. And in fact, we're able to, the Rendition Project unveiled new data that shows that it's, at least 49 detainees. And the number that we'd had before that North Carolina Stop Torture Now was working with was much lower than that. So really making that connection from the beginning about why North Carolina. But then going into looking at, well, if North Carolina was involved in this program, well, what's wrong with that? What are the legal and political ramifications of that? So Jayne spoke about the connection with, why this is against domestic and international law, the opportunity for the survivors to tell their story, particularly sitting out now continuing consequences of the program, and then having Alberto Mora talk about the broader costs and consequences that we can look at now, a number of years later. And then those most affected as well on a North Carolina level. So having citizens in Johnston County talk about what it's meant to have the airport there. And we did seek testimony, of course, from the governor, from Johnston County Commissioners, from the Airport Authority, from those who have a different opinion on the legal aspects of this. And unfortunately, we weren't able to persuade anybody to testify publicly. But I still hope that we will receive, the feedback and the thinking from them, because it's important to have, both sides presented. So I think that covers sort of how we selected. Of course, we could have probably had a 5-day hearing, but we've been really lucky to have others who've submitted testimony to us written. So encourage people to go to our website where you'll be able to view all of it if you weren't at the hearing. Both, we're going to put up videos, but there's also the written testimony available now of all those who testified publicly as well.
So I wanted to read out part of the stated mission of the Commission, which is to do the job the government refuses to do, investigate North Carolina's involvement in the U.S. torture program and its resulting obligations under international treaties and domestic law. The NCCIT will serve as a model for other accountability efforts and help create momentum for full official transparency and accountability for the United States use of torture and rendition. So this is a really incredible mission, and at the same time, the Commission does not have a prosecutorial mandate or function, and some, perhaps, especially in the context of a law school setting, might view this as a limitation. Can you talk about what you see as the vital importance of a truth-seeking body like NCCIT in human rights advocacy work?
Sure. Well, as you might expect, I think it's hugely important, but both on the local and the national level, and it makes me think of the Eleanor Roosevelt quote about universal human rights. And she said, "Where, after all, do universal human rights begin? In small places, close to home. Unless these rights have meaning there, they have little meaning anywhere. Without concerted citizen action to uphold them close to home, we shall look in vain for progress in the larger world." So the fact that this is citizen-driven, and while we've seen that the federal government and we've heard from Christina about the lack of action on the state level, it's really up to citizens to stand up and push for transparency. I think also as we now have a president who's talked about bringing back some of these techniques, the importance of this as an educational tool is key at this moment. Both for the moment we're in now, but for future generations as well, to have this as a permanent record of what happened here. I think also it enables the voice of survivors to be heard. There's been a lot of talk and debate about the program. We've heard the Senate intelligence report came out, but nowhere have the voices of survivors really been amplified and lifted up, and I think the Commission is an opportunity to do that. And we hope that it will also engage new allies in the fight against torture. I mean, many of you were probably very little when this program was being implemented, so it's reminding this new generation, it's finding people and uniting them around this common American values of human dignity, so across the partisan divide, so Republicans, Democrats, Libertarians, around this core, human rights value and American values. And I think that it will also hopefully build some momentum for genuine accountability, both at the state level, but also at the federal level, once others have seen the impact that the Commission can have, and will show hopefully as well the respect for international human rights norms. Show the rest of the world that American citizens are taking these rights, and build support around the rule of law. And as you say, we can't bring prosecutions, but we can make recommendations. The Commission is one of its key values, I think, will be making recommendations to the state, to the local level, and also to what citizens can do to advance North Carolina as a human rights leader going forward, and not one that has this black mark in its history. So, I think it's extremely valuable and important role.
Professor Huckerby, can you talk a little bit about some of the key legal arguments that you shared in your expert witness testimony, especially around the issue of the fact that North Carolina can be held to account under international human rights law, and also the liability of private actors and how that ties to the U.S. government?
Great. So there are basically sort of three core questions under international human rights law that were implicated by the role of North Carolina in the CIA rendition, detention, interrogation program. The first big question was, do the human rights treaties that the US government has ratified bind local and state officials? And the answer under international law on that is pretty straightforward. Yes. Essentially, under international law, a federal state is considered to be a single entity for the purposes of implementation of human rights norms. So once you ratify something at the federal government level, then all officials are bound to implement those obligations in accordance with their competencies. And the US government itself has acknowledged that the federal system of government does not exempt local and state officials from the obligation to implement human rights treaties. So that was sort of a big sort of threshold question in this particular context. The second question was, picking up on Catherine's comments, what are the ways in which the US government's rendition, detention, interrogation program actually violated international human rights law that it was bound to follow? And again, I'm not going to go into all the different ways in which the USG program violated international human rights law given the time limits, but there were a couple of quite fundamental guarantees in human rights that the US government has taken on that were thoroughly violated in the context of this particular program. The first is the norm on the prohibition on torture and cruel, inhuman, degrading treatment or punishment. As Christina mentioned, the program operated by the CIA included, for example, what are euphemistically referred to as enhanced interrogation techniques. It's what we call torture under international human rights law. And so the prohibition on torture itself was thoroughly implicated by the USG program. It's particularly important to emphasize with regard to that prohibition, that's an absolute prohibition. What was particularly interesting, not only during the hearings, but also more broadly in policy debate in America, is it's become quite acceptable to have a conversation about whether torture works or not in this country, as somehow that may be relevant to the legal question. It's thoroughly irrelevant to the legal question. The ban is absolute. There are no circumstances where the national emergency, national security can ever justify torture. The second really important area of international human rights law that the program infringed is what we call the prohibition on non-refoulement, prohibition on transfer to torture, or calling it inhuman, degrading treatment. So just as you can't torture as a government, you can't send folks to be tortured somewhere else, right? That's a prohibition on transfer. What we call is rendition or extraordinary renditions. This is the actual process of being prepared for a flight by a CIA rendition team on the tarmac of a foreign airport, being put on a flight and subject to torture and cruel and inhuman degrading treatment on that flight, and then being sent either to a third country for interrogation or to a CIA black site. So the prohibition on transfer to torture and CIA treatment and punishment was heavily violated in this context. The third area of international human rights law that's particularly relevant for understanding the nature of violations that occurred from 2001 to 2008 in particular is the prohibition on an enforced disappearance. Again, it's an incredibly fundamental norm in international human rights law that you cannot place someone outside the protection of the law. And incommunicado detention in CIA black sites, I think just to be really clear about, a CIA black site means that you are held entirely off the record, okay? You often don't know where you are yourself when you're held. Actually, you almost never know where you are when you're held in a CIA black site. Your family has no idea where you are. And that in itself is inherently an infringement of an enforced disappearance under international law and also a violation of the torture norm. One thing to particularly recall and to pick up again on Catherine's point about the need, and Christina as well, for ongoing investigation, is that under international human rights law, you have a right to a remedy if your rights have been violated. So that means until you have some type of recognition for the rights violation that you endured, the government is in continuing violation of their obligations under international law. So the US government continues to be in violation by virtue of its refusal to effectively investigate and compensate individuals who were held in the detention rendition program. Finally, as you sort of reflected, Professor Fujimura-Fanselow, in your comments, a core question for the Commission and more broadly for this particular activity of the US government was, to what extent does international human rights law speak to private actors, okay, so to non-state actors, such as private airplane companies or private contractors who might be involved in interrogations, for example. And again here, the international human rights law has some pretty clear things to say. The first is, obviously a government is responsible for the acts or omissions of its own officials, but you also can't outsource what you are not allowed to do under international human rights law to a private actor. So you can't outsource to a militia, you can't outsource to a private airline company, for example. And you also, even if you if the relationship that we're talking about is not one of outsourcing, in the sense of that more direct relationship, you can't turn a blind eye to what private actors are doing in your jurisdiction. So, the more and more more and more officials at the local and state level were mindful of what was happening in their jurisdiction, they had an obligation to investigate, to prevent, and to punish the acts of private companies that are violative of international human rights law.
Thank you for consolidating such a complicated area of law. And can you talk a little bit about the involvement of the International Human Rights Clinic and the work of the Commission?
So the clinic has been really privileged to support the work of the Commission. In particular, the types of work the clinic, International Human Rights Clinic and the Advanced International Human Rights Clinic has done with Professor Fujimura-Fanselow and myself has been to do some fact-finding work, some data visualization, so really trying to, so very often when we talk about numbers and like sort of number of detainees or talk about dates or number of interrogation checks, it can be very easy to lose the magnitude of those violations, and so we've sort of worked to think about how best to visualize that information. Also some legal analysis, particularly around these sort of questions of international human rights law and the applicability at the local and state level. In particular in the clinic, what we're interested in doing is bringing together a whole, as Christina, as you talked about it, and Catherine as well, which is the connection between the local and the global. These were things that were happening here in North Carolina. They were also happening all around the globe. I mean, these were secret prisons by the CIA were hosted in multiple countries. They were traversing multiple airspaces of countries, and to really connect those dots. And so, for example, we really looked at not only what was happening at the federal government level in terms of mapping out key authorizations, but also how that was playing out in North Carolina. At the same time, as Christina mentioned, what was happening in Europe, where actually there were ongoing inquiries into the role of planes taking off from North Carolina. that were naming the N3793 and N313P, the planes that were involved. And so we were interested in particularly interpolating that information and really thinking too about the efforts of local citizens who really led the push for accountability. And in all of that work, I want to acknowledge particularly our students we've got Khaled Fayed, who is here, as well as who worked very closely with his teammates, Maria Borges and Catherine Colver. And we have 3 incoming students in the clinic, Gabrielle Scalings, Sophia Durand and Lauren Hughes, who will also be working to continue to support the work of the Commission.
Professor Coleman, can you talk a little bit about, as a commissioner, what was some of the most striking or surprising things to you over the course of the 2 days of hearings?
Yeah, well, unlike the other members of this panel, this was not my area of expertise. So I really was a citizen member of the commission. I was learning about both what our government was doing, but also about international law, obligations both of national government and state and local governments. I also saw this as a good vehicle for doing these kinds of inquiries in other areas. For example, it seemed to me that an inquiry like this, focusing on the criminal justice system, would also work. I became a client of Jayne's clinic, in effect, because this is not my area. They were very generous in briefing me, getting me up to speed. They provided a lot of the background materials that the commissioners read about this problem. The thing that struck me probably most deeply at the hearing was the testimony of the victim and the wife of another victim. I think as Americans, we think very highly of our system of government. We think very highly of our, or at least what we claim as our adherence to the rule of law. So to hear people who had been kidnapped, put in airplanes, taken to unknown locations, tortured, and then dumped back in the streets when the government learned that they had taken the wrong person. That, to me, that was devastating. And the idea that it was done by our government and not by the current administration, but by administrations I think that we would have expected more of, and particularly the last administration we would have expected would have made clear that this is not what America does, and we would have held ourselves accountable. So I hope that what comes out of this is that we can do a final report that lays out what we have learned from these extraordinary witnesses, and that we can make some recommendations both for our government as a whole, but also for our local governments and local officials who chose to put their heads in a hole and pretend that this stuff was not going on.
And can you also reflect a little bit about on the experience of working with your co-commissioners who came from a variety of different professional and potentially ideological backgrounds, and what that diversity brought to the commission?
That was part of my education too. This really was an extraordinary group in terms of both their experiences, their expertise, their passion for what we were trying to do, the audacity of undertaking something like this. It was, I think there is no relevant area of inquiry that we didn't talk about, that we didn't think about how we might present this to the public. This was a public education effort too, and so the question is, how do we present this so that the public understands what our government did? Without commissioners who really had the expertise and experience, both in government and in international matters, I think it would have been very difficult to structure a commission like this. But also the staff, because I mean I think they were at least as important as the commissioners, if not more important. They ultimately put this all together, and it really was an extraordinary thing to be a part of.
And finally, you've touched on this a little bit in terms of talking about recommendations, and I know that's very much an ongoing process, but can you say a little bit about the report writing and recommendations that the Commission will be coming out with?
Well, I probably should let Catherine talk about that, but we are in the process of both setting deadlines for ourselves and also staffing the various committees that will at least do first drafts of parts of the report. And that process will also include the International Human Rights Clinic, which is going to make a significant contribution to that effort. And then we're going to think about what are the recommendations that we can make, both based on the experience, I think, of the citizens who tried to bring this to the government's attention and failed in the sense that the government officials weren't interested in learning about this. And so I think to make some recommendations that will change what they view as their responsibility in an area like this.
Thank you. Professor Kirk, given the work that you've done on torture in other contexts, including documenting torture in Peru and Colombia with Human Rights Watch, can you reflect on the fact that for the first time the U.S. government's role in committing torture is being examined through a citizen-led commission?
Thanks for that question and for the invitation. I think it certainly isn't the first time that the government's role in torture has been examined. I think the important proviso that you include in that question is that it's a citizen-led commission. In fact, we have quite a long history as a country of using torture, and I think that's something that kind of sometimes gets lost in the discussion of this. This is not the first time, and this is not the first revealing of the use of torture by the American government. But I think that one thing that's very important is that it is often the case that governments will justify the use of torture because of some sort of threat, terrorism, or some sort of civil disturbance, and we are not immune to that rationale. I think there's many Americans might think, and I think Jim put it really well, that they think, well, our government wouldn't do that, and of course, we have laws and we have procedures and we have a military and this and that, and in fact, it was for me, again, I think someone said that you all were pretty young when 9/11 happened, but it was astonishing how quickly we moved from a country that could be said on the international stage to be supporting most human rights norms to a country that was actively pioneering new ways to abuse human rights, and in particular on torture. It's been pointed out several times that without any sort of accountability at the federal level, it is left to citizens to say, this shall not pass. And so that's why I think this is vital, not just the commission itself, but the work that Christina and North Carolina Stop Torture Now has done to make sure that there is some level of education, some level of activism, and some level of reporting to governments, whether it be the state or the federal government, about this. It's an essential role that this commission is playing.
And on that last note, talking about the importance of the commission and also the work of Christina in North Carolina Stop Torture Now, can you reflect on that, especially in the current political context, in which, for example, as Catherine also mentioned in her comments, President Trump has been rumored to be considering privatized rendition once again?
Yeah, I think it's really actually interesting how this broke down in the hearings themselves, because we had a number of both active duty and retired military, FBI, CIA come and say, look, we are convinced that this not only didn't work, going to the Jayne's point about this debate in the United States over whether or not torture works, but that we knew this was wrong as we were doing it. But because the orders were coming from the very top, people fell in line, and I think that could very well happen again. And so one of the things that I'm hoping that this commission accomplishes is leaving a marker to say, we know what happened, here's what happened, this is why it was wrong, this is why we can't do it again, and to make partnerships that are not only with human rights folks or people who care about the rule of law, but also make partnerships within the military, within the CIA, within the FBI, within the organizations, governmental organizations that would be called to do this, and say, look, you can say no. Not only can you say no, but you should by law say no, because it's no defense to say this was superior orders. That's not a defense in terms of the prosecution of torture or any sort of human rights violation. So I think that this commission is an important milestone in that argument.
Thank you. So I would love to open it up to questions and comments. In just a second, I wanted to give first the speakers an opportunity if there's anything you wanted to respond to that anyone else on the panel had shared.
Look forward to questions.
Okay, wonderful. So questions and comments from the audience.
First off, I want to thank you all for being here. This was absolutely fantastic. And I guess I think it's worth noting that we are here at a law school for the professionalization of lawyers, and at numerous points in this story that you've told, lawyers weren't doing their jobs. They were either enabling it in terms of justifying it, or they were enabling it by way of not prosecuting it or not raising it. And I'm wondering to what extent you think reports like this are important for norm making and professionalization of lawyers and legal education as well.
Well, I mean, I think you're right, but I think we also have to acknowledge that there were lawyers who were trying to hold the government accountable. When the Watergate happened back in the 70s, lawyers were involved in that, and they were a big part of the criminal conduct that occurred. And one response by the American Bar Association was to require all law students to take ethics, believing that somehow maybe if we had to take a couple of hours of ethics, we would be better lawyers. I don't know how that worked out, but maybe, I mean, in terms of a marker, maybe that's what a report like this might do, which is that Robin, before she left, she talked about partnerships that we can make, and she named some agencies that you wouldn't ordinarily think of as partners in this kind of an effort. But there were people throughout the government who thought that this was wrong, and that it was ineffective, and that we shouldn't do it, and it was un-American. They were ignored by the people who were in charge. So maybe this is a way to change that. When all of you become officials responsible for American policy, presumably you'll remember that we really ought to try to uphold our values.
I think that's a really great question, and also fully agree with that response. I mean, to say exactly that lawyers were heavily involved, as you articulated, right, in the providing the authorization for the program, particularly by the infamous torture memos, what you're thinking of, and also in failing to investigate and prosecute. As I mentioned, that obligation of the United States government is ongoing, right, to provide redress for these past violations. But as Professor Coleman said, lawyers have been incredibly instrumental also in challenging these programs, and I think it's important to emphasize that actually the role of North Carolina, and particularly the role of these flights, has been put on trial elsewhere in the world, right? So we have cases in the European Court of Human Rights that have directly, we actually have particularly, and there have been 6 cases filed in the European Court that have particularly touched upon the experience of individuals on board of N379P or N313P. And the court has been very conclusive in determining the ways in which the treatment of those individuals constituted violations of international law and also of regional law. There have also been 3 cases, again, focusing purely on the North Carolina connection. 3 cases in other regional bodies, including the Inter-American Commission on Human Rights and the African Commission on Human People's Rights. There have been regional inquiries. There have also been a number of cases in the United States, as Coleman mentioned, that have actually sought to challenge directly the role of aero contractors, and they haven't proceeded for a variety of reasons linked primarily to the invocation of state secrets privileged by the government. But there is an effort to use the law as a key tool of accountability. I think the biggest lesson when you look particularly at the role of law and lawyers in the post 9/11 moment is law can do violence. This wasn't an example of where folks sought to operate illegally, totally. Actually, it's a complete opposite. It was almost a hyper-legal effort to construct a justification under law, for these policies. So law can do violence, but also law can undo violence, as well. And I think we've kind of, part of our role is to be very vigilant, in not allowing legal arguments to be held hostage to rights violations.
Just make a couple of related points. One is, I think in this moment it's been shocking as well how some of the authors of those torture memos are now back in government. That the lack of accountability means these guys are popping up again and it may not be in positions directly related to where they're going to be able to approve such policies again, but still it just shows that there's no, it's not even take a course in ethics. It's like you get a promotion to do something else. So, and the other is on, the politics, I think, of this have changed. When this issue was brought up at the beginning of this administration about a year ago, and Mathis came out and said it's, his piece on, it's easier to give a BA, you're going to get more information. It was interesting how Republicans in the Senate, particularly, even those who 10 years ago were maybe not on the right side of this, do not want to bring this up again because they've seen the kind of politics and the backlash and they're worried about the investigations and the long arm of the law. So I think also, we've, as you say, that we've got this opportunity to use the law to our advantage, but it's also been the politics around this that have changed because the costs and consequences have now been seen, and they don't want to go down this road again. It wasn't, particularly a political winner for them. So I think that will help prevent a return, at least in this environment we're in now.
Curious about this sort of locally driven piece of this. How was this sort of originally discovered and uncovered, and then sort of who drove the commission to start with, and then also sort of on this side of things, what has been the public engagement, and what's your sense of sort of the public response in a state that, went for Donald Trump, which is great. There's sort of assumptions about what people think about these things, perhaps, but what have you sort of seen in that engagement?
Yeah, I think so. Originally, we found out that North Carolina was playing this important role in the CIA rendition and torture program because the media were uncovering it. There was a seminal article in the New York Times in May of 2005 that had pictures of Smithfield, North Carolina, and showed that aero contractors headquartered at the Johnson County Airport was the CIA's domestic aviation hub for their rendition and torture program. And we thought at the time, because we hadn't started yet, we thought, well, exposing that, certainly our state officials will sit up and take notice and do something about that, right? It's prominent in the New York Times. So over the years, such a variety of approaches to such a broad array of public officials occurred that we were able to really understand how much more difficult it was going to be than we had thought, and how much stronger their resistance was to publicly acknowledging the problem, to even saying North Carolina is anti-torture. And then, of course, over those years, as we were trying to get Cooper and Purdue and Easley and McCrory to do something. U.S. public opinion was starting to shift too. So back in 2006, 2007, we stood in the Walmart parking lot in Johnston County and petitioned people, gave them a petition and said, so your local airport is actually hosting torture taxi flights. What do you think about that? Should that be investigated and stopped? And 70% of the people that we approached signed the petition saying, yes, that should be investigated and stopped. That's in Johnston County, which is a pretty conservative part of the state on average. But, I don't know how that would turn out if we asked people now. And part of the problem is that through a variety of media vehicles like the show 24 and like Zero Dark 30, the movie, people's opinions about torture have been distorted and manipulated so that they think that torture is effective and they think that it keeps us safe. And so I think American public opinion is manipulable on this issue and is also somewhat shallow, that if you give people contrary information, people will revise their impression. But they haven't been getting that contrary information from opinion leaders who matter to them in terms of having the authority to actually investigate and hold people accountable. So I think that's the problem. And that's what ultimately led us to realize we need a bigger vehicle. We need something like a Citizens Commission that has the authority, that has the prominence, that has the respect that grassroots networks don't get. And so that led to the formation of the commission. Now, what has been the public response to the commission? I think it's been great for the people who are aware of it. The challenge is always to get sufficient exposure in the media and through networks of allies, shall we say. So part of what we've been doing is reaching out statewide and approaching religious organizations, approaching student groups, and asking people to hold events where we educate people about the fact that this is going on and talk to them about the promise and the potential that the Commission of Inquiry has to really bring this to a new level. So that's an ongoing effort that Stop Torture Now and the Commission are engaged in, is trying to reach out to, in Asheville and Winston-Salem and Wilmington and let people know that this is happening and why it's cool and unique and promising.
Can I add something on the public response? I wanted to echo something that Professor Coleman mentioned and also that Catherine actually mentioned too, which is it's particularly striking to me when you think about accountability for the post 9/11 rendition, detention, interrogation of the US government, is exactly the inability of the American public to connect with the victims of this program. And that's not accidental. This was a program that was entirely put overseas for a variety of legal reasons. To come back to the question we had about that, so to try and avoid the application of US constitutional law, for example, that would be applicable if you had folks in the territory. But it was really an externalization effort that had legal implications, but also very much that there would not be relatability, that we would think about the victims as the other, that not our neighbors, the people that are trying to harm us, right? And I think what was particularly striking to me, and I think will be really, to me, is formative to public response, is when you create a moment, as you did with the Commission, where you can have victims and their families talking directly via Skype to an audience. So their words are not filtered by prosecutors or lawyers. These are people speaking and talking about the impact of these policies on their day-to-day lives. And I think that was an extraordinary, for me in the hearings, it's one of the most extraordinary moments, was watching an American public. And I've been exposed to testimonies before for a variety of reasons, including having been involved in representing individuals who are held in these CIA prisons. But there's something very different about watching the direct contact between victims and their families and the American public. And I think once we take away government interference and take away these barriers that have been put up, that have been designed to dehumanize victims and to deny accountability, that's where public response really kicks in. I think that sense of injustice is so acute that it can't be ignored.
Christine? Thanks to you all. My question is quick enough. It's just, do you see any tension between the effectiveness arguments that are being raised and the rights-based arguments, particularly in terms of accountability? There's a lot more accountability in the sense in saying that if there was a violation of human rights rather than your government made a poor policy decision about something that turned out to be ineffective. And was that raised a lot among the commissioners themselves? And I understand that you want this public education on both elements, but how did you navigate that tension internally?
And I can start from the legal perspective. I mean, Christina, as you know, more than anyone, that this is a real challenge when you think about what we call sort of instrumental arguments when we make human rights arguments, or intrinsic, right? Intrinsic being this is illegal, it's inherently torture violates international norms. That's an intrinsic, inherent argument. And sometimes we make more instrumental arguments as human rights advocates, right? Which is it doesn't work or it doesn't achieve a particular goal. And there are huge trade-offs when you make instrumental or strategic sort of arguments in this way, particularly when you're talking about norms like torture, which are inviolable, which are absolute prohibitions. And so I'm going to be very, very careful about, there's a slippery slope argument when you begin to talk about if something that we know is illegal can be allowed if it works. That's something that's really tough to negotiate. I also say, that dabbling in the space of torture is ineffective as a lawyer is very difficult for a variety of reasons. Not only because, very often, again, it's coming from personal experience, when you are facing folks who are involved in implementing national security policies and they tell you that actually torture does work, and we can't tell you why, that's protected by national security. So it's you create an extraordinarily, apart from having violated from a very fundamental legal norm, you create an incredibly difficult strategic argument for yourself too. And so I think there needs to be an extraordinary carefulness around the way in which that's approached. And definitely, from a legal perspective, it's very worrying anytime you hear discussions about whether torture works or not. It's an irrelevant question from a totally irrelevant question from a legal perspective.
I just would add that I agree completely with that, and I think it's very important for people like Jayne to say it's irrelevant whether it works. In interacting with North Carolinians on the issue, I have come to the belief that you need to make all kinds of arguments. Many people don't engage with the issue as an issue of morality. And that is, I think, the reality of where we are in the United States today, that's not the first question that many people confront when they think about whether torture should be done in the future. And so I think it's been very important to have the voices of former interrogators like Steve Kleinman, who testified to the commission. As a professional operating from a behavioral science perspective, how do you get good information in an interrogation? You want the fullest possible recall, and you want the fullest possible divulgence of the best possible recall, I think is how he put it. And you don't get that through creating psychological and physiological stress on a person. You get damaged recall and you get resistance to divulgence. I think you have to talk to Americans about that, because people are not necessarily going to come with you because it's wrong.
Just to pick up on that, when in 2008 I worked on a campaign to ban torture, which was, we did exactly that, to be able to break through to the public. This campaign was to convince the next president to pass an executive order that would ban enhanced interrogation, black sites, and allow the Red Cross access to prisoners at Guantanamo. And the way we built momentum for that campaign was to combine both the moral arguments. So we worked with the National Religious Campaign Against Torture to bring along the religious voice from the different denominations saying this is morally wrong, with the national security voice to say, well, not only is it morally wrong and against American values, but it actually doesn't work. And so combining, we had over 250 religious leaders, former national security advisors, secretaries of state, secretaries of defense, interrogators, FBI, CIA, others, sign this declaration of principles as part of this campaign that ended up, Obama passed an executive order on his third day in office outlawing torture. But I think that worked, and that got attention because we combined those arguments together, to convince people that if you were wavering, because people always bring up the ticking time bomb, well, look, interrogators tell you it doesn't work. And so I think that's to educate people and to bring it forward, as you say, you have to you have to open up to all those facets of arguments against its use.
We've unfortunately come to time, but thank you all for being here, and thank you again so much for the speakers.